it's a Dutch case presented before the Dutch courts about 2 Dutch shipping companies. And then it gets a bit complicated because those shipping companies ordered their ships to be made or produced abroad in Poland. And they did that by, in Poland, those ships were built with the help of employees who came from the DPRK, so DPRK workers. And those people were treated very badly under very bad labor conditions, which were similar to modern slavery. And what we allege is that those Dutch companies knew about the conditions under which those workers were put to work, and nonetheless continued to order ships there and cooperate with those Polish shipyards. And by doing that, they profited from that slave labor, but also they took ships which they knew were actually coming from crime, because producing a ship in that way is, in fact, is a crime. And by then taking that ship, putting it on the Dutch market and making money with it, that's, we say that accounts to money laundering. So that's the second heavy legal argument that we're making. And we've also talked about fencing, which is the same reasoning that we use with the money laundering. So we say basically you take a product which you know is coming from crime, you didn't actually commit that crime, had the labor exploitation yourself, but by then monetizing that product, you are facilitating and you are cooperating, and that constitutes separate crimes. And that's what this case is about. Of course, we hope that this will be a groundbreaking case, setting a new legal precedent. We do believe that the facts that we have alleged are built on very strong evidence. We used a lot of research has been put into not only this complaint, but into the larger problem in general. And luckily, we were lucky enough to be able to build on that research and present that to the court and the prosecution. So we hope that indeed those companies will be prosecuted. That's still the main aim of the case. If not, then we hope that the Court of Appeal will reject the case on a legal reasoning, which can help us to build future cases and also send a signal to perhaps the politics to legislators saying, listen, the current law as it stands is insufficient, and these are the aspects that should be changed in order to stop these practices and protect people in the future from being exploited in this way again. So what we did is we filed a criminal complaint with the Dutch office, the Office of the Dutch Prosecutor, a public prosecutor, and they looked at the case, they studied the evidence that we presented, but they said in the end they could not specifically decide how much profit was actually made by those Dutch shipping companies. And they said in order to establish whether or not they actually profited from the crime, we need to know what that profit was. And they say it's very difficult to decide that because it's difficult to place labor costs within the larger aspects of the total shipbuilding companies and the total shipbuilding, the cost to build a ship, basically. They also agreed with some of the statements that we made in the criminal complaint, which is very interesting. So they agreed that the labor conditions under which the DPRK workers were put to work amounted to labor exploitation, which is a crime. So they accounted to human trafficking, basically. And that's a very important finding, which we could use then, because the next step, what we did is we challenged the decision of the public prosecutor with the Court of Appeal in The Hague, and we said, listen, we don't agree. Can you please relook at the case and the evidence that we presented? And we think there are some misreadings of the law on the side of the public prosecutor, and we would like your judgment on that. So that's what we did, and that's where we stand now, and we're currently waiting for the Court of Appeal's decision on the case. That's a difficult question. I think one of the main challenges in cases like this is to prove that companies knew about those conditions. and the products that they order and the suppliers that they use, that they know about those circumstances and the crimes that are committed along the supply chain. I think that's always one of the challenges. We think we have enough evidence in this case to establish that those specific Dutch shipping companies knew. But what you do see with new legislation, for instance, the new CSRDDD, is that there is a much more legislation coming forcing companies to do that investigation in their supply chain to make sure that those types of crime can no longer exist within their supply chain. And if they do that, they should take steps to avoid that and heal the process, basically. So from a preventive point of view, there's still some steps to take, but you do see that the legislator is more and more aware of those circumstances and trying to help victims by creating stronger laws. I mean, those companies did have to appear before the Court of Appeal and did have to give an answer to the allegations that were made. So at least there was some form of accountability there already. Secondly, even if the case is dismissed, we believe that with the press coverage around the case, with all the reports that were published in the course of this case and in the course of the investigations that have been going on, a lot of has changed, and also a lot of signals were sent to legislators that this is a real problem that should be dealt with. And you do see in the legislative field quite a few changes at the moment when it comes to corporate due diligence, when it comes to corporate accountability. And what we hope is that even if the case is dismissed, it will send a very strong signal to the legislator that there is still some work to be done in order to avoid these cases in the future. So I do think those are all very strong aspects of strategic litigation, which make these cases important, even if the end result is maybe not a successful prosecution and conviction. You can still achieve quite a lot along the way. And I think that's something that this case really shows.